Number 129, the matter of Lisa T. versus King E.T. Thank you.
May it please the court, Richard Hirschfeld for appellant King T. I'd like to reserve 2 minutes, if I may, for rebuttal.
Of course, sir.
I'd like to focus on the second point in our brief, whether or not the family court has jurisdiction to issue an order of protection.
Must the named party in an order of protection have to be found to have committed a family offense?
Absolutely, Your Honor, and that's why.
Where does it say that?
What is the authority for that?
What is the authority for requiring a party? It's statutory. It's 812, I believe, says that for the family court to have jurisdiction over a family offense proceeding, there has to be A, a family offense, and B, a requisite relationship between the parties.
And what was the family offense that Mr. E.T. was found to have committed?
He wasn't found to have committed a family offense.
I don't understand that jurisdictional argument. The way I read 812, correct me, it's jurisdiction to have the case in the court. So there's an allegation of a family offense, they get jurisdiction, they issue temporary order of protection. Isn't that confusing two things? I mean, has anyone ever read this statute to say that before, other than the dissent in this case?
I think courts have frequently read the article to require a family offense before they can issue an order of protection.
Well, not before they can issue a temporary order of protection.
I believe it's before they can issue any order. The temporary order of protection is not subject to appeal.
So does that mean that when a petitioner comes in, files a family offense petition, alleges the proper jurisdictional predicates, and says, and gets an ex parte order, which it happens all the time, the court issues the order, that order is of absolutely no effect because the court had no jurisdiction to issue it?
Oh, no, I'm sorry. Either I'm misunderstanding you or you're misunderstanding me. There's no question that the court has authority to issue a temporary order of protection
Okay, so
if the
then
petition is facially sufficient.
Okay, so then that happens, and as has happened here, the respondent violates that order of protection.
The
okay?
temporary order of protection.
The temporary
yes.
order of protection, exactly. And then, doesn't 846 and 846A say that you can file a violation petition of such a temporary order of protection?
Absolutely.
Okay. So then, and it also addresses what happens if you're found to have violated that temporary order of protection.
It does
And
indeed.
one of the things it allows the court to do is to enter a permanent order, or another order, a new order of protection, correct?
That's what the statute says,
Okay.
yes.
And Section 847 actually distinguishes between violations that constitute a family offense and violations that don't.
Yes.
Okay. So what does that all mean if what you're saying is correct?
Well, it means several things. First of all, I think you have to, you start with the fact that the family court obviously is a court of limited jurisdiction. So where is its jurisdiction to issue orders of protection? That jurisdiction is found in 812 and in 832.
How about Family Court Act Section 115, which sets forth the jurisdiction of the family court?
That as well.
It includes all the various provisions and also says such other jurisdiction as is set forth in this act. Why doesn't 846 and 846A provide that jurisdiction?
Because what you're looking at is issuing an order of protection for facts which don't constitute a family offense. And I don't believe 846A provides for that.
So what do you think then are the range of remedies, if any, for the violation of the temporary order here?
There are a variety of other remedies that are listed. First of all, if the violation is in fact a family offense, then you can issue an order of protection.
And here it wasn't.
Right. But there are other remedies, as Justice Gesmer noted. You can find them in contempt if the proof is beyond a reasonable doubt. You can order attorney's fees. There are a variety of things that you can do. But if you look at 846A,
So you can find them in contempt, could you incarcerate them?
yeah, if the proof is beyond a reasonable doubt that there was,
If there's a family, if it's
Yeah.
a family, and it says that?
Yeah.
In the statute?
yes, it does. I believe so.
In 846A?
I believe so, yes.
It distinguishes between when there's a family offense underlying the violation.
No,
Okay, that's what I'm,
okay,
because that's
I'm
what we're
sorry.
talking
Yeah,
about
right.
here.
But what it says is, if you find a violation of the order, temporary order of protection, you can issue a quote-unquote new order of protection. And the way I would argue that should be read is that first you have to have that order of protection, not a temporary order of protection where there's no opportunity to appear, to refute, and where in this case it lasted 2.5 years, but an actual finding that there should be an order of protection.
What was the conduct what was the conduct that your client was found to have committed? What was the gravamen of that finding? Was it a injury to an individual party? Was it an injury to the court, violating the court's order? What was the conduct?
I mean, I suppose it's a combination of the two. It was an email that didn't fall within the parameters of
But
the
wasn't
permitted emails.
was that email the subject of the family offense petition that was ultimately dismissed?
Now, there were a variety of emails. There were emails that were the subject of the family offense petition that the court rejected as a family offense. And then there were emails that were alleged to have violated the temporary order of protection, which the court agreed violated it, but still didn't rise to a family offense.
So what was the conduct that that court found that your client had committed in order for the court to put the order of protection in place?
2 emails, I believe, that did not relate directly to visitation and therefore were prohibited by the temporary order of protection.
Okay, then I misunderstood your argument, because I thought your argument was that the conduct that your client committed, violating the temporary order of protection, was an act against the authority of the court.
Well, it was in that the email violated the permitted email. It was beyond the scope of the permitted emails, so it did violate the authority of the court.
And
in
did
that
not
respect.
support, would not support or did not support a finding of a family offense.
That's correct. There's absolutely no possibility that what was found to have take place would constitute a family offense.
So what was the appropriate action for the judge to have taken?
Well, you know, this is a case that sort of falls in a gray area. I'm not sure what the appropriate action would be.
Should he
because
have referred it for a contempt?
Only, yeah, as Judge Gesmer pointed out, only on a finding beyond a reasonable doubt, which was not the finding here. So they could not do that. I suppose there would be some form of perhaps a civil contempt remedy that they could exercise. There are attorney's fees, sanctions, but here...
Isn't what the judge actually did here a far less draconian remedy than all of these alternative remedies?
I don't think it's less draconian to have, after 2.5 years of a temporary order of protection for potentially a single email, to have a new order of protection put in place.
Maybe
Well, it's
shown
better
up,
than going to jail,
It's less draconian than going to jail. That's,
and not overnight.
no.
As I recall, the dissent
Yes, no,
had up to
but-
6
But
months.
I don't think that was an option absent of a finding beyond a reasonable doubt.
Would a criminal court have had jurisdiction, in your view, to issue this permanent order of protection if the violation had been transferred to that?
No, because there was no family offense.
Yeah,
so-
but a criminal court doesn't need a family offense.
But they need a violation of criminal law, and that's the family offense, the violation of criminal law, and there was no violation of criminal law.
So, counsel, let's say we agreed with you. How would that further the purposes of the Family Court Act?
I don't know that it would further the purposes, but it wouldn't expand the purposes beyond what the legislature granted. It wouldn't expose someone for a single email to an order of protection where that, I don't believe, is the intention of the statute. You're looking, under the Family Court Act, under Article 8, you're looking for conduct that is a family offense, and that's what you're trying to protect against. You're trying
Aren't
to,
you also looking, as is true for any court, for individuals who appear before the court and are subject to its orders to comply?
absolutely, absolutely, Judge. But in this case, where you don't have a family offense, I don't know that the order of protection is the remedy for noncompliance with an order of the court. That's where you have contempt sanctions. You don't have the, I understand it's not as pleasant an alternative, but
Well, yeah, and what does the respondent do? Say, well, I don't think she's going to be able to prove her case here, so I can violate this order indiscriminately, but, you know.
no, absolutely. I mean, I can't speak to what, you know, a potential respondent would do, but you act at your own risk, and the fact that you don't think she can prove her case doesn't negate the temporary order of protection. It just, within the possible consequences, is not a new order of protection unless what you do constitutes a family offense.
So does the fact that the judge did not find the sending of that email to be a family offense, and then he puts in place an order of protection directing Mr. E.T. Not to speak to this woman, does that concern you, that might be criminalizing his conduct, his conversations?
Yeah, absolutely, Judge.
Does that have any First Amendment implications?
No, I don't, you know, frankly, I'd like it to, but I don't think it does, because you have an order that says you can't communicate with the other party except under certain circumstances, and when you do, I don't think there's any First Amendment protection to that.
Even though a family offense had not been
No,
found?
because you've got the temporary order of protection, which, until there's a decision that it no longer applies, still prohibits him from doing what he did.
Thank you, counsel. Counsel?
May it please the court, Randall Carmel for Lisa T. My first time here in the Court of Appeals. I appreciate it.
Welcome, sir.
Thank you. I will take the lead here and not argue point one, which I don't think is at issue, unless any of the bench has questions
I have
regarding
one question. I'm sorry to take away from your time on this, but just in terms of notice, actual knowledge, that whole subject area, some of the case law seems to refer to service or knowledge. And I'm just wondering if you can tell me that typically in family court, is service required to be personal, actual personal delivery, or is service sometimes by mail or other means?
Personal service is preferred, but there are substituted service provisions that are allowed once there is a certain showing that efforts have been made and you're not able to personally serve.
Okay, sort of like the CPLR.
Right,
Okay.
similar.
Thank you.
And in this case, he was actually personally served with papers on October 3rd of 2013. And then subsequently, he was sent notice. And these notices, I'm sure the court knows, has bold letters, bold language indicating the consequences of violations or not adhering to the court's orders. So if there are any other questions on point?
No, you may proceed to the second issue, sir.
Okay. There's no language in Article 8 of the Family Court Act that requires a family offense finding to issue a final order of protection in response to a respondent violating an existing valid order, whether it's temporary or final. I think that's clear.
So I just, and this is a really micro technical question, which maybe you can help me out, not having sat in the family court. So the decision of Judge Kelly that's dated May 27th has two docket numbers on it, right? 032396-12 and then 032396-1215C. The actual order of protection that he then issues pursuant to that decision just has one docket number. And so if we're talking about jurisdiction, I'm trying to understand did he issue that final order of protection on the underlying petition that got dismissed? Or did he issue it on the one that alleged the violation?
It's my understanding, and I'd have to do a little research here right now to go back, because I hadn't prepared for that specific question, but you can see this 15C would be in a subsequent filing. So I would think that the docket number listed here is the docket number that relates to the petition that was filed for the violation. And that's why I think he limited it here rather than including the docket which he dismissed.
Correct. So if that is the case, then it's not that the court lost jurisdiction because the underlying, jurisdiction over him, meaning the father here, by having dismissed the underlying family offense petition.
I would agree with that.
Okay.
And I would just note the court's attention, because it hasn't been mentioned yet. There's Section 828 of the Family Court Act, which is the Orders of Protection Act, which provides for temporary orders of protection and procedures in which the court needs to adhere in hearings for violations. And this court, Judge Kelly was very aware of this, and he handled the violation proceedings thoroughly. And so he followed the procedures that are set forth in that article, and then once he made a finding that there was this willful violation of a temporary order, he then went to the statute which allowed him, and I'll refer to Section 841, to allow him to issue that one-year order of protection. And I would submit that it was in furtherance of the purpose of the Family Court Act for him to do that, rather than to do one of the other enumerated dispositional alternatives here. I think as been pointed out in my brief, but in the appellate court's decision, the other alternatives really are not practical here. We don't want to send him away, punish him into jail when he is visiting with his son. I mean, it's a problem that he can't communicate better with the mother, but incarceration is not going to really serve anybody's purpose, and really the child's, wouldn't serve the child's best interest. He's got assigned counsel below. He doesn't have money, sort of to put a contempt order and ask him to pay money. That doesn't make sense either. To suspend judgment, that doesn't make sense. I mean, the only thing really here to make sense was just to give a little more assurance that the father act within bounds that are appropriate in communicating with the mother. And I think that's all that happens here.
But isn't that assuming that he had indeed committed an offense to begin with?
No, I don't. I disagree with you. I think that the violation itself shows that he had a problem confining himself.
Well, a problem complying with the court's orders,
Well,
right?
the court-
As opposed to whatever his interactions are with her, with the ex-spouse.
I have to disagree, because I think that the order of protection specifically said, limit your communication with the mother to emergency situations, okay? So it was about his communication. It wasn't, they're not mutually exclusive. He did violate a court order, but he also did violate
But is your position that the order of protection here is a sanction for committing an offense, a family offense, family court offense?
No, my position here is that the Family Court Act, Article 8, provides for temporary orders of protections. Procedures are set out for violations of those order protections, and there's nothing in the statute under Article 8 that would prohibit a court from exercising the dispositional alternatives that are available in 842 once a violation petition has been found by clear and convincing evidence.
And
That's
Thank
all
you,
it's-
counsel.
Sorry,
Oh,
just had one.
yes, of
So
course.
if on day 364 he sends another email like this one, the court can then, in your view, issue another order of protection for a year as a sanction for that violation, this can continue indefinitely.
Theoretically, yes.
Thank you, counsel. Counsel?
Unless there are any questions, I have nothing further. Thank you.
Thank you.